Their patent sucks, so why don't you invalidate it? Part 3. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. This is the third of a multi-part video series on processes for invalidating U.S. patents. This considers two patent office proceedings called the IPR, or Inter Partes Review, and the PGR, or Post-Grant Review. They are similar but not identical. A post-grant review can be initiated within 9 months of a patent's issuance, and it can be based on any of the grounds for invalidity in the patent statute, including lack of enablement, lack of written description, indefiniteness, prior sales of a product, like basically on sale bar, or prior uses, public uses of a product, the public use bar. So the full panoply of defenses are available. If that 9 months has passed, you can't institute PGR. You can institute an inter partes review, or IPR, but that can only be based on claims, assertions of novelty or lack of novelty, and assertions of obviousness, and it can only be based on patents and printed publications. These both proceedings are basically a series of briefs that are filed, first to decide whether to institute the proceeding, and second, after it is instituted. There are some expert declarations typically, and there's some limited discovery of the declarants, and there's some documentary discovery, but far more limited than in a district court case. And essentially, it's sort of like conducting a trial on paper. There are no live witnesses examined in a courtroom or anything like that. But it is, more efficient in some ways, or many ways, than district court case would be. And so people have been instituting quite a few of these since they were initiated in the America Invents Act. One drawback of a PGR or an IPR is the estoppel provision, which means that if there's something a ground you raised or could have raised in the IPR or PGR, you cannot raise it later in a district court case. So you don't get two bites at the apple. You don't get to say, I have this piece of prior art and try to knock out the claims in an IPR and then do it again in court later. You're going to be stopped from doing that. Also, these procedures relative to an ex parte reexamination are very expensive. The patent office fees alone, just to request them, are over $25,000 for each of them. And once they decide to institute it, you have to pay, I think, at least that amount. It's a little more again. So you're talking over $50,000 if these proceedings get instituted. And that's just in patent office fees. You haven't paid an attorney or an expert witness anything. But it is still far cheaper than district court litigation, which will be the subject of our next video. I hope that helps to keep you out of trouble, and I hope to see you here soon.